Now with David and Mario from Bartier Perry. I think Mario's going to head off with the first. So can we all welcome Mario from Bartier Perry? Thank you.
Thank you. Thank you everyone for having us here this morning. My name's Mario Rashidring and I'm one of the partners at Bartier Perry. I'd like to start off by acknowledging the traditional owners of the land upon which we meet today. I would also like to pay my respects to the elders past and present. So today I'm going to be talking about three key things: identifying and dealing with new defects, the Australian standards and the Design Building Practitioners Act and the duty of care, and systematic defect claims. So some of these things you guys might be familiar with already, but I thought it would be a useful reminder to see how some of the courts have been treating these things in some recent cases. So the first case that I wanted to touch on today is that of Parkview. Now, this is a fairly usual case in that you have an owners corporation who are raising a whole lot of defects and commence proceedings against a builder and a developer. But what is, I guess, unusual or interesting about this particular case is the way in which limitation periods were examined. Because what was considered in these proceedings was the issue of defects becoming apparent after the expiry of a statutory limitation period, where proceedings were already on foot. So you have a situation here where proceedings are commenced in August of 2016, and when the proceedings are commenced, 85 defects are raised. Some of them are major, some of them are other defects. Now, jump forward a few years. In July of 2021, you have the owners corporation who want to amend their claim. And that's not unusual, but they effectively wanted to abandon the majority of those 85 defects. They wanted to raise new defects and also a breach of the duty of care under the Design Building Practitioners Act. Now, the Civil Procedure Act effectively allows a plaintiff to amend its claim after the expiry of the limitation period to add or substitute a new cause of action if it arises out of the same set of facts as the first set of cause of action. So what the court needed to consider in this particular case was whether or not changing the specific defects from the 85 defects to another set of defects effectively brought in a new cause of action. And if it did bring in a new cause of action, well, did it give rise to the same or substantially the same set of facts to enable the court to hear the matter pursuant to that particular power? So in the particular instance, what the court said was the owners corporation should be allowed to raise the new defects, and it's not a new cause of action, but rather once a claim for a breach of the statutory warranties are raised, that jurisdiction is enlivened. Now, the nature of those defects can change and can be substituted. And they said that a claim of that kind, that is a breach of the statutory warranties in Section 18B, were best regarded as a claim for a breach of a single contract which incorporates those warranties, and generally that an amendment to a claim that introduces additional departures or defects will not give rise to a new cause of action which would otherwise been out of time because the court's jurisdiction is enlivened. Now, the court made a comment that Now, it wasn't an issue that was decided in this particular case, but they did say there may be a distinction between major and minor defects. That is to say, if minor defects aren't raised, but major defects are raised at the start, it then wouldn't be appropriate at some latter point to then introduce minor defects. So that's one of the cases in which a court has dealt with new defects or different defects being raised later. And this case has received a fair bit of attention recently. But one of the, I guess, nuances is NCAT in the tribunal, it has slightly different powers, and there are slightly different pieces of legislation that empower NCAT or the tribunal to deal with these types of claims. So the case of Christelle Designer Homes in Wood is a situation where a tribunal is faced with a similar issue being agitated by an owner. Now, in this particular instance, you have an application that's filed. Now, the application is filed within the 2-year period after the completion of the works, but the application is a little bit generic. It basically says that there's a claim against the builder and that there are some specific defects, being water ingress and a minor defect relating to painting, but then it had a sort of catch-all provision saying that there are other defects to be identified and that an expert report will be provided in due course. Now, the owner then served a points of claim document. Now, that points of claim document had a little bit more detail in it and raised a fair few defects which weren't contemplated initially. Now, the builder took issue with it and said, well, it was really something that the owner should have raised at the outset. And ultimately, the builder was unhappy with the outcome here because the owner was successful and they had a money order in the sum of about $194,000. The builder appealed within the tribunal and then went down and subsequently appealed in the Supreme Court. Now, in raising its challenge in the Supreme Court, there were a few key issues that the builder contended and suggested that based on those reasons, the owners or the tribunal had fallen into error. The first was that the tribunal erred in its determination on the basis that the points of claim itself was filed outside of the 2-year limitation period. So even though proceedings were commenced within a 2-year period, the points of claim and the detail around the defects came later. And the tribunal also fell into error in considering defects that were raised in the points of claim, but not in the initial application. Now, the court, in considering the challenge made by the builder, examined the particular powers that the tribunal had and effectively found for the owners and rejected the builder's claim and rejected it on the basis that pursuant to Section 41 of the Civil and Administrative Tribunal Act, the tribunal is empowered to extend the period for doing anything under any legislation in which it has jurisdiction. And effectively, the tribunal may extend the statutory time limit for raising any non-major defects arising under the same cause of action, and that it would in fact be contrary to the purpose, the overriding purpose of the tribunal to require an initial application to be detailed to the same degree that a court would require. And that if the tribunal is designed to facilitate the just, quick, and cheap resolution of the real issues between the parties, and that if the tribunal was confined to only resolving defects that were particularized in an initial application, the owner would either be required to seek relief in court or abandon those claims, leaving the real issues unresolved, meaning the tribunal would be acting inconsistently with its duties. So it's an interesting case in that it adopts a similar rationale to the court in the Parkview case, and effectively makes clear that whilst as much detail should be put into an initial application and points of claim at the outset, it's not necessarily going to be a bar to raising these issues later, provided that the particular claim has already been enlivened within the time frame. Now, each case is going to be decided on its particular facts, but this has been an approach that's been adopted recently by both the courts and the tribunals. So I'm going to talk briefly about another case, the owners and De Silva. Now, this is a case that looks at the Australian standards and the duty of care that arises under the Design Building Practitioners Act. Now, this case related to some remedial building works that were being undertaken by the builder, and subsequently, the Owners Corporation raised that there were a number of defects relating to water ingress. Now, the owner's claim was framed in two parts. The first was a breach of contract in the usual way, but they also raised a breach of the statutory duty of care under the Design Building Practitioners Act. Now, the builder adopted a fairly novel defense. It said, well, I was mistaken about the contract. I didn't really read it. I just thought it was a document that I was signing for insurance purposes and for WHS purposes. Unsurprisingly, the court didn't accept that. The builder then argued, well, if I'm wrong about that, I say that the contract was varied such that I was not required to comply with the building code or with the Australian standards. Okay, very brave approach to take, but that's what that's the approach that he adopted. Now, the court, unsurprisingly, was not a fan of that argument either, and effectively said that as it related to the contract arguments, didn't accept that there was a variation to the contract which dispensed with the builder's requirements to comply with the Building Code of Australia or the Australian standards. But putting aside the contract for the moment and looking just at the duty of care argument, the builder accepted that he owed a duty of care pursuant to the Design Building Practitioners Act. But he said that, one, I wasn't required to comply with the Australian standards because of those variations. But also, when it became apparent to him that the works weren't going to comply, he said, well, I didn't need to stop the works because there was already an agreement in place. Now, the court in that instance said, look, we just do not accept that. There is a duty of care that exists, and that duty of care is to exercise reasonable care to avoid economic loss from defects. Now, the builder was required to perform the works in accordance with the Building Code of Australia and the Australian standards as they related to waterproofing. And the builder had breached that duty of care by failing to perform the works in accordance with those requirements. So what this suggests to us is that not only are the Australian standards and BCA and all the other relevant specifications relevant for contractual claims, but equally, when you've been asked to prepare a report dealing with the Design Building Practitioners Act, this is certainly an issue that may fall within the scope of that report as well. Now, I'm going to touch on one final case, and it's a bit of a reminder of the principles that the courts and tribunals look at when dealing with systematic defect claims. Now, this is the case involving a owners corporation and SPS building contractors. Now, this involves development in Tweed Heads. There are 45 townhouses. The key complaints relate again to water ingress. Proceedings are commenced within the relevant time frame. Both parties have various experts involved, and ultimately it's listed for an 8-day hearing before the court. Now, by the time the matter was heard, there was an agreement about a number of defects, and there was only about 50 defects which remained in dispute, as well as, I guess, the extent of the rectification work that would be required. Now, critically here, we have a situation where the key defect that related to about 26 of the 45 townhouses was LVL beam defect, a waterproofing issue effectively. Now, the expert for the owners had undertaken testing of that LVL defect in townhouses 25 and 27, but didn't undertake any testing in the balance of the townhouses. Now, there are a few reasons for that, and we'll come to it, but that was a critical issue in dispute here. And because that testing hadn't been undertaken in the balance of the townhouses, the builder's expert said, well, I don't accept that this particular defect exists in the balance of the townhouses. And this was a real point of contention, because the consequence of this was fairly significant in terms of the quantum that was being alleged. So in the proceedings, the builder and the builder's representatives relied on an earlier decision by Justice Ward in the Owners Corporation and Kellen Rigby Holdings. And that was a case that, again, looked at a very specific issue dealing with waterproofing and whether or not a systemic defect could be established. And in that particular case, there was, I think, an absence of water stops in bathrooms of a 14-unit block. And Her Honour said that it could not be inferred that waterproofing was deficient in the remaining units based on the evidence from 3 bathrooms, stating the fact that the subcontractor defectively performed work in a small number of units does not warrant a conclusion that it did so everywhere else. And she again reiterated that in these cases, the burden of proof lays on the Owners Corporation. And in that instance, their decision to carry out limited destructive testing was, again, fatal to their case, because she did not find that on the evidence before her in that case that there was evidence of a systemic defect in the balance of those bathrooms. So that was an argument that the court embraced in this decision as well. And each case is determined on the particular facts, but what let down the Owners Corporation in this particular case was the fact that the owner's expert had undertaken the testing of these particular units and specifically said in his report, I think further testing is required for the balance of the townhouses. And that testing ultimately wasn't done. Now, that's not a matter that sits within the expert's control. Often it's a matter for the Owners Corporation and the legal representatives. but that was something that came out in the cross-examination and was a significant factor that the court took into account because it was open to the owner's corporation to undertake that testing, and there was no reason why that testing was not undertaken. The other critical issue here was the expert for the owner's corporation, whilst they said there was a defect in townhouse 25 and 27, and this was the nature of the defect, they did not identify with any specificity how the defect came to be. They did not say that it was a defect that arose because of workmanship or it was a defect that arose because of a faulty design. Now, that piece of information was critical again because the owners corporation were trying to suggest that a similar style of design or similar build approach was taken with each of those townhouses. So it must be inferred and could be extrapolated that the same two defects would exist in the balance of the townhouses. But because that further testing wasn't done and there was no evidence as to the specific cause of the defect, the court in this instance was not willing to accept that the defect existed in the balance of the townhouses. Now, at some point during the course of the proceedings, the owners corporation probably got the vibe that they weren't going to succeed on this particular case or on this particular point. So they then pivoted their argument to suggest that, well, okay, even if we're wrong about wrong about that particular issue, there is a significant risk here that there could be a catastrophic failure of waterproofing as it related to the balance of the townhouses. And it would be appropriate for the court to make a monetary award representing 75% of the cost of rectifying the defect, which would fund an investigation together with rectification. So again, a fairly bold approach taken by the owners and one that the court wasn't receptive to at all. Because fundamentally, the court said, if no defect has been established, then there is no breach of the statutory warranties, and damages cannot be awarded on the basis of risk. There needs to be a defect. So first and fundamentally, if there is no breach established, then there can be no award for damages, even though there may be a catastrophic risk that may or may not materialize. So again, it's an important reminder of the way in which courts and tribunals look at these defect claims, and I guess a good example of how an owners corporation's case became unstuck because they didn't undertake the testing that was required to make out their case.
Explain to the court how you get to your conclusion. And that includes putting in any calculations, etc., that you've done or modelling that you've done in your report. Case that Graham and I were in a short time ago in the tribunal. Two engineers, different opinions as to what the scope and the method of rectification ought to be. One engineer had done the modelling was in his report, and to the extent that calculations were required, they were in his report. The other engineer, who was proposing a different method of rectification, hadn't done modelling. He had done calculations apparently, but they hadn't been replicated in his report. And so the tribunal member said, in that circumstance, I'm going to accept the opinion of the engineer who has shown me how he's got to where he says we should be, and not the opinion of the other engineer who's basically saying, well, I'm very experienced, I'm very knowledgeable, I have the qualifications, so basically take my word for it. So that's one of the prime reasons why one expert might be preferred over another. So what are the takeaways? You're explaining things to a lawyer. I mean, Ken said about that, the Christelle case, maybe there was a bit of a disconnect between the lawyers and the experts. the judge, the tribunal member, is not necessarily an expert, probably isn't, well, certainly won't be a technical expert like you guys. So you need to explain to him or her why your opinion should be accepted. So logical, consistent, well-reasoned. Make sure you address the issues at hand. Don't go off at tangents, because if there's a good lawyer on the other side, or even the judge or tribunal member himself or herself, they will pull you back and say, no, that's not the question we're dealing with. This is what I need to know about. Disclosure analysis. Don't hide things. Explain how you got there. Explain your assumptions, what you've assumed, because you might be lawyers will often ask you to assume certain facts. So if you have made an assumption, make sure that that's clear. And remember, at the ultimate, you are a witness for the court. Your ultimate duty is to the court. So don't get defensive. Don't engage in banter with the lawyers. Don't start being a bit smart, because the court won't like that, or the tribunal member won't like that. Cool, calm, just give your opinion, unemotional, and then you're more likely to be accepted. So that's the part of that. So any questions? Nope. Okay.